and this is the first year we have someone coming in who's a litigator by trade, Lisa Coppola, but who also handled one of these cases for us, an asylum case, and had a very unique experience because this was not what she was used to. Extremely experienced litigator, but immigration court was some new world for her. She'll be coming in this afternoon to present, especially for those of you who do litigate for a living, how it differs from what you normally do and how shocking it can be in some instances, and different. And what is similar, of course, too.
Before I begin, I just want to say that Batavia has basically a huge variety of people from all over the world. We've handled cancellation and removal cases from probably every continent that there is. We've handled asylum cases from every continent. Recently, I hadn't had any cases involving Australia and New Zealand, but we do have one right now. Not a great asylum case, but there is a case involving a New Zealander presently in Batavia. I want to cover the basics of asylum law, and we're going to go through the basics. Please interrupt with questions if you don't understand a concept that I am covering or talking about. But we're going to just go through the law first, and then we're going to go quickly through some ideas about preparing your case and pointers for preparing your case. I'm not going to go into detail about that because this afternoon's presenter, Ms. Coppola, is probably going to go into that a lot more detail because she handled a very difficult asylum case that she's going to describe in detail. Okay, the law on asylum is basically in the Immigration and Nationality Act, Section 208. Under the U.S. Code, it's Section 1158. And its regulations are in the Code of Federal Regulations in Section 208. So, you know, 208, 1158, you can find all the laws. The substantive laws or standards in asylum are also interpreted by case law. Case law both interpreted by the Board of Immigration Appeals as well as by the different circuits. So there may be a difference in the law for asylum between what happens here in New York in the Second Circuit versus Los Angeles in the Ninth Circuit or other circuits in the country. Okay. The main definition, the main thing you have to understand is what is a refugee. A refugee is any person who is outside her country of nationality or country in which she last habitually resided if she has no nationality. And that person is unable or unwilling to return to and unable or unwilling to avail him or herself of the protection of that country. Okay? So they can't go back because of past persecution or a well-founded fear of future persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So the keys there are persecution, so it can't be just discrimination or harassment. It's got to be a well-founded fear or past persecution. And it has to be on account of those five elements: race, religion, nationality, membership in a particular social group, or political opinion. And we're going to go through those all carefully next.
So, woman would be part of a political...
We will talk about what is and is not a particular social group in a few minutes.
Women as a whole or not?
Women as a whole or not. There could be a group that's based upon gender, but not necessarily just the large group of women in a particular country. A refugee may also be a person who has been forced to abort a pregnancy or undergo involuntary sterilization. So there is a sort of separate definition of refugee for persons who are been forced to go through this particular type of abortion or involuntary sterilization. How does one become a refugee? Basically, there's two ways: by fleeing his or her native country to a third country and then being admitted to the U.S. as a refugee. So all refugees, all asylees are refugees, but not all refugees are asylees. If you're a refugee in your third country, let's say you were living in Burma and you were in a camp in Thailand. The American government could be meeting you in Thailand and declaring you a refugee and helping you resettle on the west side of Buffalo. That's happened to many thousands of people. Buffalo, Pittsburgh, all over the country. Those are refugees who are determined to be refugees outside of the United States. By applying for and receiving asylum, when you're present in the United States after you arrive here. So an asylee is someone who's applied for asylum once they've gotten into the country of the United States. Everybody follow that? A refugee is outside, determined to be refugees, resettled here. An asylee is someone who's come here and applied for asylum. Safe third country. A person may not apply for asylum in the U.S. if he or she would have had full access to full and fair procedure for determining an asylum claim in a country to which he or she may be removed pursuant to a bilateral or multilateral agreement. The U.S. has such an agreement with Canada, which basically means that if the person comes into Canada and they could have sought asylum in Canada, our government's going to say, you should do it in Canada, and not necessarily let them in the United States to do that. But there are exceptions. One exception is if the Attorney General finds that it's in the public interest for the person to receive asylum here in the U.S. Okay, we'll give you a common application of what it means for a safe third country. And we'll do it from this side of the border. A foreigner comes into the U.S., but decides to seek refugee status in Canada rather than in the U.S. They present themselves at the Canadian border for refugee processing. He or she must show that she has a qualifying relative in Canada in order to be allowed to pursue the asylum claim in that country. So that if a person has a brother, sister, parent, uncle, aunt, I'm not sure exactly how far out it goes.
It's right here.
Oh, okay, there it is. Qualifying relatives, it includes spouse, common law partners, child siblings, uncles, aunts, nephews, or nieces. So, just short of cousins, seems to be basically the line that's been drawn, but you have to prove that that person is a relative. So you have to have some actual proof in terms of birth certificates or other proof that that person is a relation. Okay. The next notice is, for us, we have to not send anybody to the Canadian border to make an application for asylum because they're already here. And the safe third country concept would prohibit them from seeking that asylum in Canada unless they have a qualifying relative.
And by prohibiting it means that if they show up at the Canadian border and they can't get in because it's a safe third country, they're going to be turned around to the U.S., to CBP, and they're going to land at Batavia. Okay? Now, by the time we give you your asylum cases, we're screened for all this stuff.
Right.
But we're just giving you some background information so you understand it.
Yes.
Is that criteria the same for coming from Canada into
Mhm.
Yes, it's the same agreement. It's the same proof would have to be shown.
qualifying relative here?
Yes.
It happens in the reverse much more. It's very rare. This is the common scenario, especially with French-speaking, like the many French-speaking Africans. They land in the U.S., but they all want to go to Quebec because they can speak the language. And they get to the border, and they can't prove the qualifying relationship, and they get sent back. They're detained and put in removal proceedings, and they become your client.
Right. That happens very often, and part of the reason is also because I think there is a myth prevalent out there that it's easier to get asylum in Canada than it is in the United States, and in our experience that is not necessarily the truth. There are groups in the United States that basically do assist people in going into Canada to seek asylum. Vive la Casa here in Buffalo, Freedom House in Detroit, and a Vermont Refugee Assistance in Montpelier, Vermont. But again, please, that's not something you'll be dealing with in terms of sending or deciding to send people to Canada. Who is ineligible for asylum? Okay? I want to begin this by explaining that asylum is not the only ground of relief that a person has if they're fearing persecution or being killed in their home country. There are basically three different levels. Asylum is the most basic and the most beneficial. You get asylum, you can eventually become a citizen. There's another standard that we're going to talk about called withholding of removal. That is a standard where you have to show not only just a well-founded fear, but a likelihood of persecution. We'll talk about that in a moment. And then there's a higher standard even than that for people who have committed very serious crimes called relief under the Convention Against Torture, where you not only have to show that it's likely you'll be persecuted, you have to show that it's likely that you'll be tortured or killed in your home country. And even people who have committed some very serious crimes are eligible for relief under that Convention Against Torture. So I just want to say, if you're not eligible for asylum, please think that there may be other things available to those people. Okay, so who is ineligible for asylum, the basic level? Any person who ordered, incited, or assisted in any kind of persecution. So if you yourself have been a persecutor, you're not going to be eligible for asylum. A person convicted of a particularly serious crime. An aggravated felony, which is a specific type of crime, which we don't, again, you will not have to get into because we will be screening these cases for what relief is available. Okay, if a 5-year sentence has been imposed, that is considered a particularly serious crime, and the IJ, the immigration judge, will find them ineligible for asylum. Or if there are serious reasons to believe that the person has committed a serious non-political crime outside of the U.S. prior to their arrival, additional grounds are reasonable grounds for believing the person is a danger to security, or a person is involved in terrorist activities, or associated with terrorist organizations, or the person was firmly resettled in another country prior to his or her arrival in the United States. Okay, what is firm resettlement? We just said that's one of the grounds for not being eligible for asylum. A firm resettlement is an offer of permanent residence, citizenship, or other type of permanent resettlement. So if you've gone to another country, let's say you are fearing for your life in the Congo, but you have moved to France and been a permanent resident in France, that could be an example of someone who has been firmly resettled in a foreign country. Of course, if that person has become a French citizen, it's even more clear that there's been a firm resettlement. Okay, but there is no firm resettlement if entry into a third country was necessary consequence of flight or persecution, where the applicant arranged onward travel or developed no significant ties. So if someone was fleeing from Honduras and they traveled to Guatemala and Mexico, and maybe they spent 6 months in Mexico as they tried to travel up to the border, but they didn't receive any kind of offer of settlement or legal status in Mexico or Guatemala, that's not a firm resettlement. They had to travel through those countries in order to get to the U.S. border. Okay? Applicant's residence in the third country was substantially and consciously restricted by the authorities of that country despite an offer of permanent residence. That's a bit confusing, and again, that would be a legal issue that would have to be developed and would not be something that you would have to engage in determining.
Can I ask a question?
Yes?
But under the safe third country rule, could a person who traveled from Honduras to Guatemala, Mexico to the U.S. be deported from the U.S. to Mexico because it's considered a safe country?
No. The safe country rule is just about where you would apply for asylum, and is really just a bilateral agreement between the U.S. and Canada. Okay? In terms of whether or not they could go back to a third country, that is based upon whether they have had a firm resettlement and have established enough ties so that that country would accept them if they were to be deported to that country. So if you're a French permanent resident, but you're from the Congo and you seek asylum, if the government can send you to France, then they will do that, and it'll be much more difficult to prove an asylum case from France than it would be from the Congo. But that's not, safe third country is a separate concept from the idea of a firm resettlement. Okay?
I understand that, but so the person could not have sought asylum in Mexico?
Oh, anybody can seek asylum wherever they want to. But if they were denied asylum in Mexico, because we do not have this agreement with them, they could still seek asylum here.
Although it will come into, I mean, if the court knows or the government finds out that there had been an offer of asylum in a third country, they're certainly going to bring it up and they're going to argue it's firm resettlement.
Right. If that person had won the asylum case,
Yeah.
yes, that would happen, absolutely. Exceptions. Okay. Oh, I'm sorry, the 1-year rule. So, in other words, another reason why you would not be allowed to seek asylum is if you did not apply for asylum within 1 year of entering the United States. An applicant must show, by clear and convincing evidence, that the application for asylum is filed within 1 year of his or her last arrival. Again, you are applying for asylum, the burden is on you to meet the requirements for asylum, including this requirement of filing within 1 year of your arrival. The exceptions are changed circumstances which materially affect the applicant's eligibility for asylum, such as change in law, change in country conditions, new activities, In such a case, the applicant must be filed within a reasonable time of the change. There will be two examples of changed circumstances. Somebody enters the United States from Croatia or from Yugoslavia in the 1980s. And let's say they're facing deportation in 1995, when there's a civil war going on throughout Yugoslavia between the Serbs and the Croats. Clearly, when they left Yugoslavia, they did not have a asylum claim because there was not a war going on. But perhaps then, in 95, when they're in removal proceedings, the situation has changed. A more current example would be Syria. You left Syria 4 years ago or 5 years ago, before the civil war. There may not be an issue about asylum, but there may be now, depending upon what group you're in Syria and why you might face persecution if you're returned to that country. Another example may be that perhaps there's a racial component. We have a case where someone has given birth to a biracial child, and that birth has created a potential for asylum because of the child's ethnicity in a country where there may be xenophobia or very severe racism and things like that. Okay, so those would be changed individual circumstances or changed country conditions that will be an exception to the one-year rule. Everybody got a concept of that? Okay. All right, more exceptions. Extraordinary circumstances for the delay, such as a serious disability or illness, legal disability, meaning they were under 18, they weren't aware, or ineffective assistance of counsel as defined by law. So basically, other examples of reasons why you could not or you did not meet the one-year deadline. Perhaps you were so severely traumatized that you really were not functioning well. Perhaps you spent the first 6 months of the United States hospitalized or something like that. That would be perhaps a reason to request an exception because of your own circumstances, disability or illness. Ineffective assistance of counsel. You went to a lawyer, they did not know that you could seek asylum because, I'll give you an example. Somebody who is from Jamaica may face persecution because he or she may be gay. Perhaps you went to an attorney who did not realize that being gay would be such a problem in Jamaica and therefore did not advise you to seek asylum. But you've sought some other form of relief in immigration court. That might be a reason to seek an exception to the one-year rule because of ineffective assistance of counsel. The applicant maintained temporary protected status, lawful immigrant status, or non-immigrant status, or was given parole. So that if you were here lawfully for a period of time, let's say you came in as a permanent resident, and you've been living here all the time, but now the government wants to deport you because of a crime you may have committed, you did not have to seek asylum because you already had permanent resident status. But if you now are being forced to give that up, and it's a year later, and you have a fear of persecution in your home country, that would be another exception to this one-year rule. And again, the one-year rule would only apply to asylum, not to the other forms of relief that are available.
Excuse me. I just
Yes.
have one more question about the one-year bar. So if someone was in removal for being an overstay or EWI, could they not do a defensive asylum filing and removal?
Oh, no, they certainly could, depending upon when, how long it had been since they had lost that status. If it was less than a year, then they could seek asylum and meet the one-year rule.
Let's
If it
assume
was
it's a
5
long-
years later,
Yeah.
it could be a problem. You'd have to meet one of the other exceptions.
And if you enter without inspection, then
Then you'd have to seek withholding of removal, which is the higher
okay,
form
so
of
the
relief.
so the 1-year bar could apply.
The one-year bar would apply to somebody who came in as a student 5 years ago, lost that status, let's say, right away, or came in as a visitor. I'll give you a better example. Came in as a visitor, was only allowed to stay till May of 2001, and is now seeking asylum. Well, that's probably not going to happen if the reason for the asylum was there all along. Okay, all right. Okay, so the date of admission is going to be on the person's I-94 card. So you have to file within 1 year of that date of admission. You came in July 7th, you need to make sure you be filing by July 6th of the following year. Date of entry if an applicant entered the U.S. illegally. Although this date is more difficult to establish. Somebody crosses the border, you don't know necessarily when they crossed, how long it's been. But again, remember where the burden is. This is part of the asylum proof stage, and the burden is on the applicant. The Second Circuit Court of Appeals, which covers New York, Vermont, and Connecticut, has held that arrival means arrival to the U.S., not a return from a brief trip abroad. Okay, so that you're not going to restart this one-year clock by going to Montreal for a weekend or Tijuana for a night. You're going to have to basically have left for longer than what's considered a brief trip. And again, that's a term that's been defined not so completely, but again, it would be a legal issue that would not be facing the volunteer attorneys who would be taking these asylum cases.
It might.
It might? Okay.
We have some have had
All
to
right.
deal with firm resettlement 1 year rules. Yeah,
Okay.
we definitely have.
All right. But remember, though, that if the person is saying, well, I went to Canada and I came back, that may not be enough to restart the one-year clock. That's the point of this. Okay. What if one fears return and is ineligible for asylum? So this is what I was just talking about in terms of the other forms of relief that are available. In your packet, you have a chart like this. It's from an asylum law primer. That's quite old, but this is all still accurate. It's basically telling you the basic differences between the three forms of relief that are available for people who have fear: asylum, withholding of removal, and cat litter. Okay? So withholding of removal is sort of the next standard up. A person may not be removed from the U.S. to a country where it is more likely than not that his or her life or freedom would be threatened on account of race, religion, nationality, membership in a particular social group, or political opinion. So, for withholding of removal, the standard is not past persecution or reasonable fear, or well-founded fear, it's likelihood of persecution. And again, that persecution has to be based upon these five grounds. Okay? Thank you. One is ineligible for such relief if he or she has been persecuted, if he or she has persecuted others. So that same ground of inadmissibility for asylum for persecutors also applies to this. Has been convicted of a particularly serious crime, or has committed a serious non-political crime abroad, or is a danger to the security of the U.S. The main differences are there is no one-year bar and no firm resettlement bar, because withholding of removal is mandatory. Asylum is discretionary. Okay, this is a point that I didn't make earlier. Asylum, the decision to grant it, you may meet all the qualifications for asylum, but the judge may consider this person not worthy of receiving asylum because of bad things that they may have done in the past. Okay? If they qualify for withholding of removal and can show the likelihood, that relief is mandatory. The judge does not have discretion to deny it. There was a question in the back?
Yeah, if we could go back to the one-year bar. Is there an argument or claim that can be made as far as lack of notice? I've seen a couple times that people will say to me that I was never told I applied for asylum.
No, unfortunately, lack of notice itself is not really a grounds for an exceptional or a reason to not apply within the 1 year. However, if a person has a severe mental illness and has been basically in their home and not leaving, or severely agoraphobic or severe PTSD, that lack of knowledge coupled with their infirmities could be a ground together. But just simply, I didn't know, that's not gonna make it. Okay. Where was that? Okay, yes, next. Okay, so again, asylum is discretionary. The judge can weigh different factors and say, not really. And again, that would not be reviewable before the Second Circuit. It's reviewable to the Board of Immigration Appeals, but not to the Second Circuit, because again, discretionary rulings are not reviewable to the circuit. But any ruling on the law of asylum or on whether or not the facts meet requirements for asylum could be reviewed on appeal. All right, applicant must show that it is more likely than not that he or she would be, okay, if you're not eligible for withholding, you've committed a very serious crime, you have committed a serious non-political crime in your home country, you're considered a danger to the United States, you may still qualify for relief under the UN Convention Against Torture. Okay? Here, the applicant must show that it is more likely than not that he or she would be tortured by the government of his or her country, not by a group that the government cannot or will not control. So, in asylum and withholding, the persecution can be based upon a group, the government, or by a group that the government cannot or will not control. There might be a group that's running rampant in the country. An example that comes to mind would be perhaps Boko Haram in Nigeria. The government may be trying to control it, but may be unable to. Other groups, may include different revolutionary organizations. ISIS in
Any
Syria
guerrilla group.
would be a great example. The Taliban in Afghanistan would be, I think even still now, a good example of that. But here, it has to be by the government of his or her country, the torture that we're talking about. But no on account of is required. So the torture can be based upon just about anything. It doesn't have to be based on race, religion, nationality, political opinion, or membership in a social group. You don't have to show the nexus or the connection between the torture and that, as you do with the persecution. You have to show in withholding an asylum that the persecution is based upon that person's race, religion, nationality, political opinion, membership in a particular social group. In fact, in your materials, you'll see a case that basically says that it has to be a central motive of the persecutor. That person's race, religion, nationality, membership in a particular social group, political opinion, is a central reason for the persecution. Here, none of that is required. If you show that it's likely that you'll be tortured or killed, then you've shown enough. Now, it has to be by the government. It also includes being done with their acquiescence. Or as some courts have said, willful blindness. That they willfully, intentionally turned a blind eye to that torture. An example of that, again, in our experience, has been the treatment of gay men in Jamaica. That the community itself is likely to torture or kill that person, and the government, although not necessarily doing it, has clearly turned a blind eye to stopping it, has clearly acquiesced sufficiently so that it's considered to be governmental intentional inaction, as opposed to actually done by government officials. Although in some cases it is done by police and other government officials. Torture is an intentional infliction of severe pain or suffering, whether physical or mental, for the purpose of obtaining information, confession, or as punishment, intimidation, or coercion. The torture must be inflicted, again, at the consent or acquiescence of a public official or somebody else acting in an official capacity. Again, the differences are in that chart, but basically the standards and the burdens of proof, of course, are different. A grant of asylum will allow somebody to get an LPR status, a green card, after 1 year of being in that asylum status. The other two forms of relief will not. You are going to be a person granted withholding or relief under the Convention Against Torture, and that's going to be as far as you can go, but you can stay here forever in those capacities unless situations change in your home country. Okay, if you can be returned to that country at some point in the future and not face torture or killing, they can do that. Now, I'm not aware of any cases where that has happened. Are you, Sophie?
Usually the clients are gone. I mean,
Yeah.
we wouldn't know.
Yeah, we wouldn't know. They would go somewhere else, and then, the government usually doesn't follow them. Now, if years later they commit a more serious crime, and they look and say, well, things are not the same in your country, then perhaps they could be sent home to their own country.
15.
Okay, a grant of asylum will allow one to petition for a spouse and children to enter. So if you get asylum, you can bring your spouse, your wife, and children. The other two, no, they'd have to find other bases to come here. A grant of asylum mandates release from immigration detention. The other two do not, although in our experience, they eventually are released from detention. Usually, in the case of relief granted under the Convention Against Torture, very often they are required to give the government 3 other countries that they might want to go to. And those countries are or are not contacted by the ICE officials, and if they're not accepted by them, then they are maybe released about 30 days later. That happened in one of our cases where a volunteer took on the case of the gentleman from Jamaica who was gay and who was he gave him 3 countries. None of the 3 countries that he put accepted him, and then 30 days later he was released from detention. In fact, I do want to say that although it may seem very difficult, we have had within the last year 2 volunteers who have taken on relief under the Convention Against Torture cases and have been successful. There may be more, but the 2 that I'm supervising both won their cases under the Convention Against Torture. Okay, again, asylum relief is discretionary, withholding and relief under the Convention Against Torture is mandatory. Humanitarian asylum. Under U.S. law, one may be granted asylum if there are compelling reasons for being unwilling or unable to return arising out of the severity of the past persecution. Okay, there is a reasonable possibility that one may suffer from other serious harm upon removal to that country. So that if you can show that you have past persecution that is again based upon those 5 reasons, the fact that you may not face that persecution upon your return may not be a bar to you getting asylum if you might experience other serious harm upon removal to that country. So that let's say someone was so severely traumatized because they were being persecuted on the basis of one of those grounds that they are now very severely mentally ill, and the country to which they would be sent back to has very little mental health resources. That could be a ground for the humanitarian asylum, even though they may not be able to prove persecution in the future, but the severity of the past persecution coupled with the harm that they would receive upon being sent home would be able to allow them to get humanitarian asylum. What is persecution? So that was the other word in our definition that we have to clarify and we have to understand a little bit more clearly. It's a threat to life, freedom, or the infliction of suffering or harm upon those who differ in a way regarded as offensive. It need not be physical harm, it may be emotional or psychological, it may involve the deliberate imposition of severe economic disadvantage or deprivation. Okay, so the second one we're saying about the imposition of severe economic disadvantage or deprivation. If you're discriminated against in your home country so that it's very difficult to find work, that's not going to be enough. But if the ostracization is so severe that there's no way to survive and care for yourself, then it may be. Okay? Prosecution is not persecution. So if somebody is being perhaps arrested for evading the draft in their home country, that would be more likely to be prosecution than persecution. However, there are claims that are made for, let's say, Jehovah's Witnesses who have a religious reason for not engaging in war, and if that's not being upheld, then you might have a combination. But generally speaking, if you're faced with legitimate criminal charges in your home country and that's why you're fleeing, that's not persecution, that's prosecution. Evading mandatory military conscription and feeling consequence of punishment may not be a basis for asylum unless severe punishment is disproportionate to the offense. So if they're likely to be jailed and maybe harmed in jail for not following the law, or let's say the conscription could be indefinite, forever, then you might have an asylum claim based on that. Acts of random violence or crime are not persecution. If a person's been severely beaten or harmed, and it's just a random act of violence by some mob that's not tied to one of those 5 groups, race, religion, the rest, that's not persecution. Discrimination, again, will not generally amount to persecution, and harassment or threats alone do not generally constitute persecution, although it could, depending upon the severity of any of this. Who is a persecutor? The government or a group that the government is unwilling or unable to control. We all understand that kind, right? Okay. The applicant for asylum must prove that the alleged persecutor has the inclination or capacity to punish the applicant for his or her belief or characteristic, and it presumes the persecutor knows of belief or characteristic, so that if you are basically seeking asylum because of your political opinion, it must be clear that the persecutor will understand what that political opinion is either through an imputation of perhaps somebody in your family who has that political opinion, or they already know you have that political opinion because of something that's happened in the past. On account of, again, the 5 protected grounds: race, religion, nationality, membership in a particular social group, political opinion. Has to be at least one central reason for the persecution, cannot be incidental or tangential. Harm arising from general conditions of civil strife in an armed conflict are not persecution. Okay? So if it's just that you are in the midst of a civil war, that's not going to be persecution. If your group is being targeted for violence in that civil war, then it could be grounds for asylum. Okay, may include actual political opinion or, again, imputed political opinion. That is an opinion which the persecutor attributes to the applicant, which the applicant may or may not actually have. Okay. Or it can be an active or specific opinion or belief that the person does actually hold. Okay, so those are ors. On account of membership in a particular social group. Now this is a very complicated area of the law. There's much litigation about this, especially for the last 10, 12 years. There are cases in your materials on the most recent ideas of what is a particular social group. I'm just basically giving you the citations, and here I'm just going to give an overall background of a particular social group so you can have an idea of what it means. A discrete group who share a common immutable characteristic, which may be an innate one such as sex, color, kinship ties, or a shared past experience, but it must be one that the members of the group either cannot or should not be required to change because it is fundamental to their individual identities or consciousness. The Board of Immigration Appeals has added basically to this general definition the idea that the particular social group must be particular. In other words, it can't be very amorphous or undefined, and it must be socially distinct. There must be a distinction to this group that is in a way that society can see it as distinct and differential. The following groups have been deemed to be particular social groups: families, tribes, and clans. That's pretty clear. Certain women who have been forced to undergo female genital mutilation, or who may be forced to undergo that if they're returned home. Homosexuals, gypsies, the Roma throughout Eastern and some parts of Western Europe. Women who do not conform to gender-specific laws in Iran, and that could also be other countries other than Iran, but right now the case law is for Iran. Certain former gang members, although the gang cases are very difficult and ones that I think you want to really research and take a close look at when developing those. Northern Ugandan children who have escaped from involuntary servitude after being abducted and enslaved. So these are groups that have been deemed to be particular social groups. Okay.
Some of them by immigration court, so they're not
Right.
precedential. Some are precedential, and others, like
Right.
the women and the northern, those are immigration court decisions, so they're not
Right.
precedential.
Yeah, the gang membership is really at this point at an immigration court level, not necessarily higher than that. If an applicant establishes past persecution on account of one of the 5 protected grounds, he or she is presumed to have a well-founded fear. All right, that got in there, but I'm glad that got in there. We covered that. But the following are not PSGs. Former non-criminal drug informants working against the Cali cartel. Case that said basically, by itself, that's not a PSG. Salvadoran youth who have rejected or resisted membership in a gang based on personal, religious, and moral opposition to gangs. Now, there are cases that have gone the other way on that, but again, in terms of anything higher or presidential, it's not been considered PSG. A Honduran male perceived to be a gang member who resists gang recruitment and membership. By itself, again, not necessarily enough. People of low economic status from China. Well, that's, probably 200 million people. So that's not been considered a PSG. Young, attractive Albanian women forced into prostitution. Wealthy Guatemalans, membership of the police or military. Okay, so these are all groups that have not been considered PSGs, either because they're not particular enough, as in the low economic status in China, or perhaps they're not socially distinct in their own country. So again, in your materials, I have provided some information, some cases about particular social group, about the case law that's currently there. I don't have time really to go into that here, but know that there also is a cite to a Second Circuit case that sort of summarizes, Poloka versus Holder, that sort of summarizes the current state of affairs. It's from August of 2014, and it summarizes sort of the current BIA case law on a particular social group. Okay. 10 minutes? Okay. A frivolous asylum application is one that will bar you from anything discretionary under the Immigration and Nationality Act. So you don't want to have your clients file a frivolous asylum application. Okay. Now that is not an asylum application that loses. Okay? Unfortunately, a lot of asylum applications don't win, but they're not considered frivolous because they're not sufficiently strong enough under the law. But it's one in which a material element has been deliberately fabricated. Okay? Not that they forgot the year that something happened, or they forgot the time, or they put down the wrong date, but that a beating that they say occurred never occurred, and of course they know that. That would be a deliberate fabrication. So it's a deliberate falsehood that's central to the claim or material to the claim, and that can be considered frivolous. Okay. And again, it would bar that person from discretionary benefits. All right. Now there are basically two ways of applying for asylum, and it was raised earlier in one of the questions: affirmative and defense. Affirmative asylum applications are from people who are not in removal proceedings, but who want to file for asylum because they want to stay here. They may have come in as a visitor, they may have come in as a student, but before that time runs out, and certainly before that 1 year deadline runs out, they file an affirmative asylum application with USCIS, and again, that's the group that gives out the immigration benefits. They'll have an interview with the USCIS person, and if that person finds that they have stated an asylum case, they will be granted, and life is a dream. If it's denied, it's not really denied, it's simply referred to the immigration court. So if somebody comes in and affirmatively represents or applies for asylum, and they are denied the asylum, that case is referred to the immigration court. And then they're in proceedings. Most often, of course, those cases are going to be decided in Buffalo because they will not be detained. So those cases will be referred to the immigration court in Buffalo. Now, there have been situations, of course, where somebody who has done that and whose case has been in Buffalo then gets stopped and detained for something else that they may have done, and the case then gets transferred from a non-detained docket in Buffalo to the detained docket in Batavia. What documents should be included? Somebody was asking about witnesses and documents. This is where we're going to get into that. All documents required in the instructions, of course, plus relevant supporting documents such as proof of past persecution and or torture, including medical reports for treatment of injuries sustained. Okay, medical evaluations in the U.S. To confirm that there have been physical and mental signs of past persecution or torture. There are organizations locally, such as Physicians for Human Rights and others, that will offer free services for those kinds of evaluations. Okay? Now we're talking about documents that should be included in either affirmative or in the defensive asylum applications, which are done for people who are already in proceedings, who now seek asylum as grounds for being able to stay here. What documents should be included? Proof that the persecution he or she alleges has occurred or will occur can also be substantiated by human rights reports or by the press. It's important to show that others have been persecuted in the applicant's country, since asylum involves both a subjective and an objective component. A person has to be sincerely afraid themselves, the subjective component, but there has to be something they can be afraid of. Okay? A person could be seriously, significantly afraid of space creatures in their home country, but there may not be any subjective or objective proof to support that claim, and they will not win their asylum claim. And the same may go the other way, but it's more unlikely that if you have an objective claim, you won't be able to prove subjective fear, but if the person has gone back and forth very often, that may show that they may themselves not be afraid of the issue. Okay, where you get these reports are Amnesty International, Human Rights Watch, U.S. State Department does a report on every single country that we recognize, and all of these are important for evaluating asylum cases. Again, family members may be included in a 589 so long as they are in the United States. Okay. When an application has been referred to immigration court, it has been denied by the asylum office. The applicant then does their case in the immigration court. Alternatively, someone in removal proceedings already, they can file it with the immigration court, no filing fee. We already sort of covered that. Proceedings in immigration courts are adversarial, so the applicant will be subjected to direct examination from you and cross-examination from the attorney for the government. Other matters to note, the I-589 is both the application for asylum, withholding of removal, and protection against CAT. There's a box at the very top of the first page saying whether that person is applying for relief under the Convention Against Torture. If they are, make sure that box is checked. Failure to attend an interview may result, again this is on the affirmative side, may result in that person's being referred, and failure to appear may lead to an in absentia order of removal. That's for any kind of case that you have in immigration court when you're not detained. If you don't show up, you can be ordered removed. If you're in Batavia, they will bring you to the hearing, so you won't have an in absentia order against you. Okay, an application for asylum is deemed abandoned if you leave without permission. An applicant who returns is also deemed, to their home country, has also deemed to abandon the asylum claim unless there are compelling reasons, such as perhaps a funeral of a parent or something like that. Appeals. If an immigration court denies, you may appeal to the board within 30 days. Again, that 30 days is critical. Okay. An appeal to BIA's decision is taken to the Second Circuit for our area because that's where the decision was made. Applying for asylum, there's no right to employment authorization, but after you filed it and it's been pending 150 days, you can then apply for an asylum, a work authorization, but they won't issue it until 180 days. And then there's something called a clock, which you'll hear about, and that's that clock of whether or not that 180 days has elapsed. Okay, I got a couple minutes left. I'm going to cover some credibility issues in terms of what to do in the hearings. Again, Ms. Coppola is going to cover this a little bit more in detail in her part, but the most important issues in most of the cases is the individual asylum applicant's own credibility. Their demeanor is crucial, lack of eye contact, flippant responses, disrespectful attitudes, all going to be problems. Prepare, but don't rehearse. It's very important to go over your direct examinations thoroughly, but do not give the questions to your client because then they will really over-rehearse them and they will come out non-genuine, okay, or disingenuous. Go over potential cross-examination questions because you know the government's going to ask questions about perhaps their criminal record because it goes to the discretion of asylum. They may go over other issues. They may go after gaps in maybe that person's life history where they don't, have anything written for the last 3 years or something like that. Make sure that those points that you can consider are gone over both in direct and cross. Okay, be prepared to obtain mental health records from past or from the detention center itself, because there is a mental facility in Batavia. Mental health problems can help explain memory lapses or inconsistent or incoherent prior statements. Examples of these mental health issues are here. Of course, they're pretty self-explanatory. Okay. Although witnesses are not generally used in asylum cases because nobody else has witnessed that kind of problem, they can be helpful in a variety of ways. If somebody has suffered similar persecution, let's say a person's coming from Sri Lanka because they're Tamil and they're facing discrimination because of their Tamil background, maybe a sibling has already gotten asylum in this country based on that reason. That would be a good example of having a witness come in to testify to what's going on with the Tamil Tigers. If they can support a person's membership in a particular social group, somebody comes in and says, I am gay, I live in Saudi Arabia, and I'll be basically killed if my homosexuality is revealed in that country, you may need to have someone come in and testify that this person is indeed homosexual. And if somebody's familiar with country conditions, including experts. Now, experts would be important. Of course, they are costly in many situations, but sometimes you can find experts, both medical, in terms of the physician's reports, like the Physicians for Human Rights, and other experts who may be willing to do their work pro bono. And if not necessarily come into court, they can be witnesses that are done televideo at other immigration courts in the country. Let's say your expert is in New York City, they can't afford to come to Buffalo, your client and VLP can't afford to pay them to come to New York City, but arrangements could be made for that expert to testify in a New York City immigration court and be televideoed to Batavia or Buffalo. They really don't allow too much telephonic experts, but they will allow televideo experts in the Batavia courts. Okay. That's really it. There's corroboration requirements, okay. This is the one most important thing I want to say is that the Real ID Act put in a requirement basically that corroborating evidence must be produced where it is reasonably available. So that if corroborating evidence in hospital reports, police records, other things that might normally be considered to be available are not, you're going to have to be prepared to explain why it's not available. And if you can show why it's not available and why that person's been unable to get it, and it's a reasonable explanation, then you can beat the requirement that the corroboration be presented and required. Okay? This is a tip I learned from Sophie a while ago, to submit envelopes if letters or documents come from abroad so that you can show that they were sent from a foreign country. Hearsay contained in letters is allowed and can be helpful, but IJs, of course, have discretion for anything hearsay to either give it some or no weight at all. Okay, all right, I'm going to stop now. Okay, I just want to basically tell you that the rest of the material is in your materials. We do have to give you time for a break. Any other questions before we continue? But the other stuff is on cross-examination and other credibility concepts, and Ms. Coppola will cover those again in detail because she'll tell you about the real-life experience of doing one of these asylum cases in depth. Yes, sir.
I just want, if you have multiple avenues for relief available, if you don't, do you have to preserve them all at the beginning by like checking the Convention Against Torture box? If you don't, do you waive those alternatives in the future?
I have changed my application at times to include things, but it's usually much better to put down exactly what you're seeking at the time that you submit it, because it goes to credibility. Okay, so now you're going to come out and say that there's a torture issue? No, you want to try to do everything consecutively and together at the same time. But also remember that you don't have to pick between race, religion, nationality. You can have any combination of them. You know, you could be discriminated against because of your, let's say you were being discriminated against by Serbs and you're a Bosnian. That could be nationality, that could be religion, because Bosnians were Muslims and the Serbs were Orthodox Christians. It could be any combination in terms of anything. So if you're unclear, put it down.
Arguing the alternatives.
Arguing the alternative is fine in terms of either the Convention Against Torture or asylum or race and religion or race and particular social group, whatever combination works and you can make a coherent argument for, go right ahead and do it. Thank you
Okay,
very
we
much.
need
I'm
to
sorry I'm out of time.
Let's try to reconvene at 5 after 11, and we'll try to catch up there, and then question and answer. Obviously, you can approach us during breaks, and there's 10 minutes built in at the end. Hopefully, we can answer some questions there as well.